Hello friends, welcome back to my channel. Now today's topic will be whether a judicial review is an appropriate remedy for a study permit application. It is. Judicial review, that means if the study permit application is refused, you can still take it to the federal court. If you believe that the visa officer has not done the assessment properly, you have presented the statement of purpose properly, you have explained your purpose of studying in Canada properly, and still the application is refused for the grounds that you have not explained. We don't trust that you will leave Canada. We don't trust that you have a genuine purpose of travel to Canada. If you have reasons like that, and if you think that, okay, you have explained properly the purpose of studies, why are you taking that course? In that case, yes, there are chances that you can take this decision to the federal court and appeal it at the federal court. The visa officer cannot plainly refuse the application for the grounds that he did not find the purpose of studies vague. I mean, he can, but if you have explained the purpose properly, then it would be unreasonable for the visa officer to refuse the application on that ground. If you have missed the SOP, the statement of purpose, if you have not mentioned clearly, if you have not clarified your intentions to study that particular program properly, and then if the visa officer believes that you haven't explained that purpose, you don't have a valid purpose to travel to Canada, to study in Canada, then it makes sense not to file a judicial review against that, because there are flaws in your application itself. Judicial review is normally considered when there are no flaws in the application. When you are perfect on your side, you have explained the statement of purpose properly, you have done the GIC, you have sufficient finance, everything is there. Still, if the visa officer refuses the application for the ground that you have gap in studies, you have not explained the purpose properly, for all these reasons, a judicial review can be filed. Now, federal court, in some cases, the federal court has held that the visa officers cannot be career counselors. So, I mean, they cannot provide career counseling advice to the students while refusing the application. So they cannot assume the role of a career counselor and refuse the application on that ground. So let's just say that if the visa officer is getting too much into why are you taking that course, or how this course would be beneficial to you, all these reasons, in that case, there can be an argument that visa officers don't have to be career counselors, and they don't have to offer the career counseling advice to the students while refusing the study permit application. So, study permit application, judicial review can definitely be done, but make sure that your purpose of study is clearly mentioned. Why are you taking that course is clearly mentioned. You have sufficient finances to study in Canada. If you have gap in studies, you have justified that gap through the SOP. If all these factors are there, and if the application is still refused, then go for a judicial review. Study permit is definitely the other factor. Other factor that has to be taken into consideration is the processing time. The process time of a study permit application, the processing time of a judicial review application is approximately 7 to 10 months. So, judicial review normally, what it does, it basically refers the matter back to another visa officer, and then they reopen the application, and they will ask for additional documents at the time of reopening the application. So let's just say that if the application is allowed or settled. Now, settlement is something that I did not discuss in the judicial review application video. But settlement, I'll discuss it now. Settlement basically means that when we submit the judicial review application, when the government lawyers reads our arguments and believes that no, there are no merits in the visa, I mean, there is truly a mistake of the visa officer, then sometimes, in many cases, we receive a settlement offer from the government lawyer saying that, okay, the decision that you seek from the court, or you basically want to reopen this matter and assign it to a different visa officer. So the government lawyer basically says that, okay, we are ready to settle this matter, and we are not seeking any further litigations, and we will be referring this matter back to another visa officer. This is settlement, basically. So we are skipping the whole hearing portion and everything. So if the matter is settled, they will reopen the application. Now, the whole process takes about 7 to 10 months. Now, if in that 7 to 10 months, if a student's IELTS is expired, or if the college or the university is not willing to defer the admission of the student to next intake, in that case, judicial review, don't do judicial review, because don't go for judicial review. Reason being, you cannot imagine how long it will take for the federal court to render a decision. And in that case, if the college is not willing to defer the admission, then simply don't do the judicial review. Or the other option is withdraw the admission from that college or university, and once the application is reopened, then get an admission again. This can be another option. But in the meantime, you have to make sure that your IELTS is still valid. If the IELTS is not valid, the IRCC may refuse the application on the basis that you don't have IELTS. So a study permit, it definitely can be done, but there are certain factors to be considered before going for a judicial review for a study permit application. Thanks for watching. Stay tuned for more videos.